Hi, good afternoon. Welcome to episode 86 of Cannabis Live. I'm Travis Copenhaver. This is
Jennifer Domingue.
And today we have very exciting news. I'm sure quite a few of you have already heard. Today we're going to be talking about the executive order that has made some drastic changes to the marijuana licensing process, primarily and most importantly, the elimination of the Marijuana Licensing Board. We're going to get right into that. Before we dive into the topic though, we just want to have a little brief statement about what we were going to be doing today.
Right, so before this executive order was released today, we were originally going to be filming basically our most frequently asked questions as well as our responses to those. And we were thinking that now that we have basically another week to really compile a really comprehensive list of questions, maybe some of our dedicated viewers would like to submit their own questions for us to consider and then hopefully address next week. So if you have any questions that you would really like for us to consider and answer for you, please feel free to comment or shoot us an email. Hit us up on any of our social media platforms and we'll be sure to try to add that in next week.
Awesome. Well, this morning, Governor Whitmer signed Executive Order 2019-7. We're going to talk about what that executive order did. We're going to give you our reactions, some of our expectations. But off the bat, we would want to say, this is breaking news. A lot of our reactions and interpretations are going to be subject to change as we see how this is truly implemented. But spoiler alert, I think we're both very excited about this move. It seems like an across-the-board wonderful thing for the industry. So let's get right to it.
Sure.
So here's basically what happened. They got rid of the licensing board.
Yes.
What does that mean?
So I think that by getting rid of the licensing board was the final hurdle in getting pre-qualified and then getting fully licensed. So you had to go before the licensing board at least once, sometimes twice, depending on how you handled your application process. And by getting rid of the licensing board, theoretically, we're able to move through this licensing process much more quickly now because it's all within the same department. Exactly.
So we're going to talk a little bit about what the executive order is doing here. So basically, we have effectively four marijuana laws in Michigan. We have the 2008 Medical Marijuana Act, we have the Medical Marijuana Facilities Licensing Act, we have the Adult Use Law, we have the Marijuana Tracking Act, etc. All of these different laws, different departments are responsible for different things. Basically, this executive order is an exercise in eliminating, bureaucracy effectively. We're now creating one agency. It's called, what is it called?
The Marijuana Regulatory
So new, I don't even
Agency.
have it memorized yet. The Marijuana Regulatory Agency. It's basically getting rid of the Marijuana Licensing Board, the Marijuana Advisory Panel, the Bureau of Marijuana Regulation. All of those powers, duties, responsibilities are now in this new agency. And one of the things that we really praised the Proposal 1 adult use system for is there was no board in place. So basically, it's making commercial licensing more consistent across the board. And it's great. I mean, this is one of the main things we talked about wanting, right?
Absolutely. So once the biggest hurdle for us was getting Prop 1 passed. Obviously, we wanted Prop 1 to be passed. But then once Prop 1 was passed, we needed to start thinking about how these different units of the marijuana regulatory schema is going to work with each other. How is medical marijuana licensing going to interact with adult use marijuana licensing? And what is that really going to look like? And so now, by effectively removing the board structure, which we had on the medical side, and directing that power to the Marijuana Regulatory Agency. We're going to keep practicing that. It's brand new.
All these acronyms are gone.
Yes. So now that we're going directly to the Marijuana Regulatory Agency, it's going to look just like, or effectively similar to the new adult use law. So we're really kind of creating more consistency across the board here.
Certainly, and it's it's an exercise in showing that the state of Michigan is working to improve this system, right? For all of its flaws, the original board, the LARA up until this point, whether you agree with their methods or not, have done a lot of work into getting us to this point, and I think everyone's starting to recognize the flaws of that system, and certainly this is probably topping the list of a lot of them. How can we get this to work better? How can we improve this system? And eliminating the board is usually, the suggestion of anyone who's familiar with what this process is. And we don't want to have a statement against the board itself. They were just doing their job. I think we respect that. But just from a design standpoint, what the board was doing was creating like another layer of approval. It's really separating the applicant, the person seeking the license, Laura, the person taking all that data, synergizing it, coming to conclusions and presenting it to a third party to make a basically subjective decision. And along that way, the applicants have significant back and forth explaining context for their history, explaining if something was done in error, providing the information Laura needed to come to the conclusions it's making. And because Laura had to basically take that data, present it to the board, and then the board has a one-sided conversation about it, comes to a decision, it really created first a time delay just because it had to go to the board. And it really created a disconnect between how that information was being processed and who ultimately made a decision on it. And it's certainly going to be an interesting next couple of months as this is put into place. So let's talk about what an executive order does.
Right, absolutely. So I think that that's a really good thing to just kind of understand what an executive order is and what sort of implementation it's going to have as this plays out over the next 60 days. So our governor under the Michigan Constitution has the ability to reorganize the agencies that are within the scope of the Michigan government. So she can make changes in the organization of the executive branch if she deems it necessary for efficient administration. She can do this by executive order, and once that executive order is signed by the governor, and if it's going to have the force of law, then it has to be submitted to the legislature. The legislature then has 60 days to basically pass a resolution, to consider and pass a resolution to deny this or shoot down this executive order effectively. If they're going to do that, there has to be a resolution, and it has to be passed by both the House and the Senate, a majority vote of both houses, and then that executive order would be knocked down. If there isn't a resolution to disallow this executive order that is passed by both the House and Senate within 60 days, then it goes to the Attorney General, it's entered as law, it's signed by the Attorney General, and we have a new law. So it takes 60 days for this, and the governor has chosen for that 61st day to be the effective date. So even though this executive order was signed today by the governor, we won't actually have any substantive changes until April 30th of this year.
And we are already hearing like news articles reporting that members of the legislature have had a consistent conversation with the governor's office leading up to this. We're not really seeing any true sign of risk for the legislature to challenge this executive order. I know that the legislature knocked down other executive orders the governor's proposed, but it seems like they're, at least today and from the initial reactions to these reportings, that this seems to be very likely to be something that everyone pretty much supports. So it's very promising at this point.
Absolutely. And I think it's important to note that the Michigan legislature has taken significant steps, even just in the 2019 year so far, to amend the MMFLA and make progress and fixing things that were of concern with the cannabis industry and how we're building out this new market within the state. So I don't really see them challenging something that is going to make it more cohesive across the board.
Right. So let's talk about like what we expect now. I've had several clients with pending applications calling me all morning asking, well, what does this mean? I'm telling most of them in broad terms, this is very good for anyone that's already submitted an application or is about to submit an application. Just from a practical standpoint, it takes out steps that are basically unnecessary in the approval process. But what we're not expecting to see a significant change is in what that process is. The application, the statutes involved for these applications still require you to make the same reportings. It's not like the application itself got easier. What's happening here is we have more efficiency. we have more consistency between the processes that we'll start seeing for adult use applications. But it's not like the application criteria has gotten easier on applicants. It's still the same pre-qualification disclosures. It's still going to be subject to the, the accuracy.
Due diligence.
Due diligence,
Absolutely.
indeed. But what is going to change is, as we kind of touched on earlier, is instead of now talking with Laura back and forth, and then hoping the board, interprets it the way you want to, you're having a conversation directly with the decision maker. You're going to be able to ensure that when context is relevant, when something can't be submitted and you have valid reasoning for it, that you can impart that reasoning directly to the department making decision on your behalf.
Right, absolutely. So keep in mind that before this, when things were submitted to the board, as an applicant, you don't get to talk with the board. It's a completely separate body, and you can't submit your own narratives to them. You can't ask questions. You can't give testimony during that board hearing. So if you're going to be going before the board, that's a group of 5 people who are reading a director's report and then maybe flipping through your file if they have other things they want to look at. But you don't ever get to communicate with that panel of individuals. Now, because you're going to be in contact with the, working on it, Marijuana Regulatory Agency on a regular basis.
We'll get it down, don't worry.
We're working on it. With the Marijuana Regulatory Agency on a regular basis, you have more control in how your business plan, how your application, how your members are explained to Lara, and what you can stress to them is going to be, this is in compliance, here's why, or this is irrelevant, here's why, and that will hopefully be taken into greater consideration.
And let's not discount the fact that the agency, the Marijuana Regulatory Agency, will have more control as well.
Yes.
What they currently have to do, and for the next 60 days will continue to have to do, is take all this data in and filter it to the benefit of the board. Mm-hmm. The way that the department who lives with it day to day, who sees your application for months, takes that data, they understand it in a way that's just impossible for a board to ever have the same kind of depth of knowledge about that application. One of the things that I think everyone wants to know is, will this make things better? Obviously we're speculating here. The proof is in the pudding. We'll see it in action. But let's just be practical. These applications, from just a design standpoint, will now almost certainly have to be processed faster. Here's why. When your application is to the point where it is ready for a decision, what currently happens is it is given to the board, you wait, you have to make a board agenda, they meet once a month, and then that board makes a decision. At minimum, there's no need to make a board agenda anymore.
Right.
It's just when Laura is ready to make a decision, they'll make a decision, right? So even if nothing else about the timeline changes, we're not now waiting for that board that meets once a month, that has to process 50 plus line items on their agenda over and over and over and over again to eventually get to yours. And that might not be as problematic now, but the board previously is not only responsible for giving you pre-qualification approval, step 2 approval, but they also have to approve new members that are managerial employees, new changes in ownership, transfers of assets. Just having Laura be the one responsible for that directly is going to save time, not only in your initial application process, but in your continuing renewal of and administration of these applications into the life of your business. What other things can we expect?
I also can expect probably a change in the appeal efficiency. So right now, if you are denied a license or pre-qualification status by the board, you can appeal that and have it heard by an administrative law judge, or what we call an ALJ. And you have this appeal process. The ALJ just makes a recommendation. They will hear testimony from you, they will hear testimony from the Attorney General's office, and then they say, this is what I think should happen. That recommendation is not binding. It just goes back to the board, and then the board will, at one of those monthly meetings, bring it up as a line item and decide whether or not to follow the recommendation of that ALJ. So without the board and having to, wait to go back before the board to see if the board is going to adopt their recommendation, it'll theoretically just go back to Lara, and if the ALJ says Lara, or marijuana regulatory agency, we think you got it wrong, then we're probably going to see faster responses on appeals. And it might take some of that subjective panel viewpoint out of it.
We're also likely to see less need for appeals because what was happening with the board is the board would get data, they'd render a decision, and based on a one-sided conversation, we'd effectively have applications that appeared to be based on perhaps incorrect conclusions and things. So just having the element of this agency, the responsible party for issuing a decision, be more directly involved in what that decision is going to just improve the whole process as a whole. We're also likely to see faster implementation of much needed things like advisory bulletins and emergency type situations. Like, for example, the board has had to make approvals for the expansion of being able for caregivers to bring products into the system for this temporary period. Instead of having to filter that through a board, this agency is going to be able to act much more directly to meet the needs as they arise. So I mean, from a synergy standpoint, we're only really looking at this through the lens of medical right now, but we also have one department that is going to also be the same department administrating the equivalent of all this on the adult use side. So instead of having two kind of separate departments doing a very similar thing with too many heads, different places, not all businesses are going to be both medical and adult use businesses, but quite a few are. Just having this all be done under one roof with one kind of streamlined set of rules and procedures is going to effectively make this a much better program in the long run.
I've always felt that if there's too many cooks in the kitchen, people just start getting in the way with each other, and that's when you start losing progress, you start losing that efficiency. And so by really kind of taking out 5 cooks in that kitchen, if you will, and having it just be all within the same family, the same agency, we're really going to start seeing greater efficiency, expediency, faster results, hopefully less appeals, and generally it'll be a better way to foster communication between the general public and the department, between the licensees and the applicants and that agency.
Exactly. One other anticipated change we're likely to see is there's already been rumblings of what was the old element of LARA, working on perhaps creating a more updated application, maybe creating some sort of applications or the equivalent thereof, a set of procedures for what a change of ownership is going to be, or some of these other actions applicants are going to be going through. And now that this will kind of be a much more streamlined process, we expect probably that to be the next focus for this new agency. A couple other things we want to highlight about the executive order. Governor Whitmer, basically it's pretty clear to see in some of the things she's highlighted in this EO, definitely is calling for public participation and continuing to make that a big factor of how this is going to be done. For one, we'll be talking about this in the news. We just saw a call for work groups. We'll talk about that more in just a second. This agency's ability to issue those work groups is not only clearly still in place, but appears to be encouraged by the language of this EO.
Absolutely, and there's another item in the EO that I think is very interesting. She has stated that there's going to be at least 4 public hearings a year to hear complaints and receive public comment regarding the Medical Marijuana Facility Licensing Act and how the agency is handling all of the licenses and if there's any issues. In this prior iteration with the board, they would allow for public comment after their board meetings, and you couldn't talk about a specific applicant, you couldn't say anything or introduce yourself as being a member of an applicant, you can't ask specific questions, but it's just an opportunity to give general public comments, and they were listened to and occasionally they were noted, but that was really kind of the extent of it for people's participation or giving comment, feedback to the department in this process. But now to have 4 specific hearings that are, or meetings, hearings, I guess is what they call it, to discuss the issues that the public is facing is huge, I think, to really kind of encourage that public participation.
I think, like, if you think about what were the other common complaints about, like, the system leading up until this point, I think there was definitely this sense of a disconnect between, like, the impact it was having on specifically patients, but just the general public, and you know, a continuing focus on public feedback is encouraging. It's again another sign to us, I would think, of just our government trying to make this program work as well as it can, and it's certainly encouraged by us. There are a few other minor things this executive order is doing that we want to highlight. One, we're not even going to touch on. Another department I didn't even know existed. It's getting moved around. We'll let the people worried about that deal with it. So they are also making some moves for industrial hemp. We have a few laws that pass at the end of the year. The 2018 Farm Bill passed at the federal level. We've had shows on that. What this executive order is doing, though, is, you know, when Proposal 1 was put in place, it was contemplated that industrial hemp licensing was going to be kind of part and parcel with the Bureau of Marijuana Regulation. Well, there isn't a Bureau of Marijuana Regulation unless the legislature, you know, decides they don't like this. So they're going to be moving industrial hemp. What's kind of going on with that?
So before, under Prop 1, Lara and the Bureau of Marijuana Regulation was going to implement the procedures for the cultivation and processing, sale of industrial hemp. And now under this new executive order, that authority is being transferred to the Department of Agriculture and Rural Development. However, the Marijuana Regulatory Agency. Got it. We're getting better.
We'll just keep saying it until it's great. Yeah.
The Marijuana Regulatory Agency will retain power to basically create procedures and standards if there's industrial hemp that is being grown or processed or sold in a marijuana establishment. So they will have some input if it's a marijuana establishment, but for most everything else for industrial hemp in the state of Michigan, it is being relegated to the Department of Agriculture and Rural Development. There
you go. And why is that what's happening? Because that's kind of what's consistent with what the 2018 Farm Bill is expecting of states to do. You know, when the Proposal 1 language was drafted, you know, the 2018 Farm Bill was being negotiated at the federal level. And now that there is a federal path to regulation for industrial hemp and those types of businesses, it's just our state, you know, greasing the wheels to make sure that that system can get up and running. We'll probably continue to do industrial hemp shows in the future. Just feel confident that the state of Michigan is doing a lot to make sure that our state is going to be able to benefit that right off the bat. It's very promising. So that's pretty much our interpretation of this executive order and today's news. We have some other news we are going to discuss. I won't, you know, it kind of pales in comparison, but we're going to go ahead and talk about some of the other news from the week as well. All right, so the first thing we wanted to talk about this week is that LAR has called people to apply for work groups. These are work groups for attorneys, individuals or businesses that expect to be in the industry, municipalities, what's the last?
Licensees.
Licensees, people who actually hold the licenses, to help them start thinking about and getting feedback for the adult use rules, regulations, and kind of system as a whole. Given that the executive order encourages the new agency to continue these work groups, we anticipate that that is still something LAR is going to continue following through on. We have links to it on our website if you're interested in participating in those work groups. If you're an industry stakeholder and you want to kind of have your voice heard, I would highly encourage you to reach out to LAR, submit one of those applications, and try to participate. Even if you're not selected, you know, they're still going to take your feedback into account. But if you're a big player in this industry, we expect you to, you know, try to help make it better. So.
Absolutely, and take note that the deadline to apply is Monday, the 4th, March 4th, 2019 at 9 a.m. So if you are looking to apply, then you should do so relatively quickly. Definitely.
We wanted to mention that our Attorney General, Dana Nessel, has announced that they're dismissing charges against 4 defendants for marijuana charges. It's continuing down the narrative that another big, you know, kind of wish list we had for Michigan after Proposal 1 is movement towards expunging, forgiving, stopping prosecution of, you know, marijuana charges, and it's a promising sign that that's occurring. The last thing we were going to mention is that cannabis company Cannabis Growth has recently announced a partnership with famous, I don't know, cultural icon Martha Stewart. Where she's going to be working with that company to develop a line of industrial hemp derived CBD products. And we wanted to highlight that as further kind of evidence of the normalization and cultural acceptance of marijuana in general across the country. Again, promising news. Like I said, all of that news kind of less exciting than our main topic today, but that's what we have for this week.
So that's basically it for our show today. If you should have any questions or comments regarding the executive order, please feel free to put them in the comments on Facebook or on YouTube. We'll be checking it periodically and happy to answer any questions you may have. Also, if you have any questions you want us to address next week on our Facebook Live show, we'll be happy to look at those and hopefully answer those as well. Thank you so much.
Thanks. So for Travis Copenhaver
and Jennifer Domingue.
We'll catch you next week. Thank you, guys.